All rise. Veuillez vous lever. The International Residual Mechanism for Criminal Tribunals is now in session. L'Osdion du mécanisme international appelé à exercer la fonction résiduelle de tribunaux pénaux actuels. Please be seated.
Good morning to everyone in and around the courtroom. Mr. Registrar, will you please call the case?
Thank you and good morning, Your Honors. This is case MICT-15-96-T, the prosecutor versus Jovica Stanišić and Franco Simatović.
Thank you. And may we have the appearances, please?
For the prosecution, I'm Grace Harbour, here with Sarah Clanton, Sarah Malikian, and our case manager, Thomas Logel.
Good morning, Your Honors. Ian Edwards for Jovica Stanišić, together with Advait Malvia. And if I could also introduce two interns, Beatrice Lau and Prachiti Venkatraman.
Thank you.
Dobro jutro, časni sud.
Good morning, Your Honor. For Simatović defense today, Melanie Vranješ, Eva Jarman, Nikola Servente, Bartosz Hensholt, and Vladimir Petrović.
Today, the trial chamber issues its decision on Franco Simatović's motion for a judgment of acquittal pursuant to Rule 121 of the Rules of Procedure and Evidence. The trial chamber heard Simatović's submissions on the 26th of February and the prosecution's submissions in response on the 28th of February. Jovica Stanišić did not submit a motion for a judgment of acquittal. Rule 121 provides that, at the close of the prosecution's case, the trial chamber shall, unless it decides otherwise, by oral decision and after hearing the oral submissions of the parties, enter a judgment of acquittal on any count if there is no evidence capable of supporting a conviction. The trial chamber recalls that the mechanism is bound to interpret its rules in a manner consistent with the jurisprudence of the International Criminal Tribunals for the former Yugoslavia and Rwanda. In accordance with this precedent, the applicable legal standard under Rule 21 is whether there is evidence upon which, if accepted, a reasonable trier of fact could be satisfied beyond reasonable doubt of the guilt of the accused on the count in question. Thus, if there is no evidence to sustain a count, or where the only relevant evidence is so incapable of belief that it could not properly sustain a conviction, even when the evidence is taken at its highest for the prosecution, a judgment of acquittal will be entered with respect to that count. At this stage, the trial chamber should not be drawn into a detailed assessment of credibility or reliability. At the same time, the trial chamber shall not completely ignore the evidence adduced by the accused in his favor during the prosecution case. It should be further noted that a ruling now that there is evidence capable of sustaining conviction on a particular count does not mean that the trial chamber will enter a conviction at the end of the case. Moreover, the fact that the evidence mentioned today has been considered for the purpose of this ruling does not indicate that the trial chamber will ultimately accept it in whole or in part. Similarly, the fact that certain evidence is not mentioned in today's ruling does not mean that the trial chamber may not rely upon it in its final judgment. At the outset, the trial chamber notes that Simatović challenges specific allegations in the indictment, including individual victims of alleged murder incidents, suggesting that they be dismissed due to lack of evidence. The trial chamber will not, however, rule on individual allegations at this stage. The plain language of Rule 121 and the relevant jurisprudence are clear. A count-based approach is required, not a specific allegation, paragraph by paragraph, or a charge-based approach. In the same vein, it is also sufficient if there is evidence capable of supporting a conviction on the basis of one of the modes of liability charged in the indictment. In this respect, the trial chamber notes that Simatović's challenges are limited to his alleged responsibility for commission through participation in a joint criminal enterprise. This decision will address Simatović's alleged responsibility under this mode of liability in relation to each count of the indictment. Only if there is no supporting evidence will the trial chamber consider the other modes of liability pleaded in the indictment. The trial chamber will first rule on the crimes allegedly committed in the Serb autonomous regions of Krajina and Slavonia, Baranja and Western Srem, and in Bosnia and Herzegovina. These crimes are charged under count 1 as persecution as a crime against humanity, counts 2 and 3 as murder as a crime against humanity and violation of the laws or customs of war, and counts 4 and 5 as deportation and forcible transfers as crimes against humanity. The trial chamber will then turn to Simatović's alleged individual criminal responsibility for commission through participation in a joint criminal enterprise. For the purposes of this ruling, the trial chamber will use the term Serb forces as defined in paragraph 6 of the indictment in setting forth its reasoning on these issues. The trial chamber will not let me begin again. In setting forth its reasoning on these issues, the trial chamber will not comprehensively discuss the entirety of the evidence or the allegations in the indictment. Instead, for the purposes of this decision, it focuses on representative evidence and incidents underpinning the counts in the indictment. Simatović submits that there is no evidence or insufficient evidence capable of supporting a conviction of the crimes alleged under any of the counts in the indictment. The prosecution disagrees. With respect to the detention and murder of civilians in the Serb autonomous regions of Krajina on the 21st of October 1991, as alleged in paragraph 27 of the indictment, Simatović contends that there is no proof that any murders occurred or that the alleged arrests of civilians were based on their ethnicity or religious affiliation. The trial chamber, however, received evidence that in October 1991, around 53 civilians, mostly non-Serb elderly or injured men and women, were rounded up in Hrvatska Dubica by members of the militia Krajina and detained in the village fire station. 6 of the detainees were subsequently released. Almost all of them were Serb or had a Serb who arranged for their release. There is evidence that those who remained at the fire station were taken away on the morning of the 21st of October 1991, along with others from neighboring villages, to a place in Bachin where they were executed. The trial chamber refers here to the evidence of witnesses RFJ 108 and Tomislav Kozarchanin, as well as exhibit P00862. The trial chamber also received evidence that the majority of the Croat civilians fled their homes, some of them as a result of the actions of the Serb forces following the takeover of Hrvatska Kostajnica. The trial chamber refers here to the evidence of witness RFJ 067 and Josip Josipović, as well as exhibit P00595. The trial chamber now turns to crimes allegedly committed in the Serb autonomous region of Slavonia, Baranja, and Western Srem during the indictment period. By way of example, Simatović submits that the evidence tendered by the prosecution in support of arrests and killings of Croat civilians, as alleged in paragraph 36 of the indictment, is incapable of supporting a conviction as it contains a number of inconsistencies. The trial chamber received the evidence of witnesses Luka Šutalo and RFJ 038 that in September 1991, Croat civilians were arrested and detained at the police station in Dai. The trial chamber also received testimonial and documentary evidence that on the 21st of September 1991, Goran Hadzic and Arkan released two of the detainees, while the remaining detainees were taken away by Arkan and executed. Their bodies were later found in the village of Chelice. The trial chamber refers here to the evidence of witness RFJ 113 and exhibit P00551, as well as forensic evidence. According to the evidence of witness Šutalo, all Croat residents of Erdut were expelled. For the purposes of the present decision, the trial chamber does not find that the discrepancies highlighted by Simatović render the evidence so incapable of belief that it could not sustain a conviction. With respect to Bosnia and Herzegovina, paragraph 62 of the indictment alleges that the murder of approximately 20 non-Serb civilians in Zvornik in April 1962. Simatović contends that there is no proof of the identity of the alleged victims of the incident. The trial chamber, however, has heard the evidence of witness RFJ 019, a Bosnian Muslim woman, that in April 1992, Arkan's men killed several non-Serb men, including the witness's husband and sons, who were hiding with her in a cellar in Zvornik. The witness was later told that others had seen the dead bodies of the men who were taken out of the cellar. She, along with other women and children, was subsequently put on a bus and transported to Serbia. The trial chamber also received forensic evidence in relation to this incident. The trial chamber refers here to the testimony of witness RFJ 019 and exhibits P016555 and P02068. In addition to the above incidents, the trial chamber received extensive evidence and took notice of adjudicated facts from other proceedings before the ICTY, showing that a state of armed conflict existed at the relevant time, and that there was a widespread and systematic attack against the non-Serb civilian population during the indictment period. The expert evidence of Jakub Bijak also indicates that in the period between April 1991 and December 1995, in the regions of Krajina and Slavonia, over 90% of the displaced persons were ethnic Croats. In her expert report, Iwa Tabo stated that in the period between 1991 and 1997, the total number of the Muslim population in the municipalities of Bijeljina, Bosanski Samac, Zvornik, Doboj, and Sanski Most in Bosnia and Herzegovina decreased by more than 75%. Accordingly, the trial chamber considers that there is evidence upon which, if accepted, a reasonable trier of fact could be satisfied beyond a reasonable doubt that murder as a crime against humanity and as a violation of the laws or customs of war charged under counts 2 and 3 of the indictment were committed by Serb forces in the Serb autonomous regions of Krajina and Slavonia, Baranja and Western Srem, as well as the areas of Bosnia and Herzegovina. The trial chamber further considers that there is evidence upon which, if accepted, a reasonable trial of fact could be satisfied beyond reasonable doubt that persecution, deportation, and inhumane acts, forcible transfer, as crimes against humanity, charged under counts 1, 4, and 5 of the indictment took place. The trial chamber now turns to this evidence concerning Simatović's alleged responsibility for the crimes charged in the indictment. Simatović submits that the prosecution has not adduced any evidence demonstrating the existence of and his participation in a joint criminal enterprise. In relation to Simatović's challenge to the alleged evidence of the common and criminal purpose, the prosecution responds that Simatović's assertion is undermined by evidence of the pattern of crimes across Croatia and Bosnia and Herzegovina, the policy goals articulated by leading members of the joint criminal enterprise and their actions. The trial chamber considers that if the evidence presented by the prosecution is taken at its highest, a reasonable trial of fact could be satisfied beyond reasonable doubt that there existed a joint criminal enterprise, the common purpose of which was to forcibly and permanently remove, through the commission of crimes, the majority of non-Serbs from large areas of Croatia and Bosnia and Herzegovina. By way of example, the trial chamber received evidence of coordinated attacks by members of the Yugoslav People's Army, the Krajina police, and the territorial defense forces in villages in Krajina. The trial chamber refers here to the evidence of witness RFJ 066, RFJ 107, and RFJ 137, as well as exhibit P01980. According to witness RFJ 066, the target of these operations was to cleanse the villages and to get the entire population out and establish a purely Serb territory. The trial chamber also refers to the evidence mentioned earlier concerning the commission of crimes in the Serb autonomous regions of Krajina, as well as the expert evidence on the significant number of displaced non-Serb civilians. Other evidence presented by the prosecution indicates that Milan Martic, an alleged member of the joint criminal enterprise, shared the goal with members of the Serb forces to expel the Croat population from the territory of the Serb autonomous region of Krajina. The trial chamber refers here to exhibit P00202. The prosecution also presented evidence on the involvement of Goran Hadzic, also an alleged member of the joint criminal enterprise, in the planning of the takeover of areas of Slavonia, Baranja, and Western Srem, in cooperation with the Yugoslav People's Army. The trial chamber refers here to exhibit P00562. Witness John Wilson confirmed that ethnic cleansing was part of the pattern of conduct of the Serb forces during their offensives in Croatia and subsequently in Bosnia and Herzegovina. The evidence is a statement by Radovan Karadzic, another alleged member of the joint criminal enterprise, to the Republika Srpska Assembly in December 1991, which reads, and I quote, "We should aim for as much separation as possible." This is exhibit P01597. In addition, the trial chamber refers to exhibits P00365 and P034 548. The trial chamber heard evidence and took notice of adjudicated facts on the takeover of Zvornik in April 1992 by Serb forces, including members of the Territorial Defense and Arkan's men, as well as evidence on the ensuing crimes against the non-Serb inhabitants of the city and the area. The trial chamber refers here to the evidence of witness Fadil Mujic, RFJ 002 and RFJ 037. The trial chamber also considers the evidence of the 6 strategic goals of the Bosnian Serb leadership, promulgated in May 1992, including the goal of separation from the other 2 ethnic communities, separation of states. At a meeting held in Belgrade in December 1993, Karadzic observed that unification with Serbia is smiling upon us. This meeting was attended by, among others, alleged members of the Joint Criminal Enterprise, including Slobodan Milosevic, Momcilo Krajisnik, Ratko Mladic, and this is supported by exhibits P01249, P01591, and P01614. This evidence, if accepted and taken at its highest, could lead a reasonable tribunal of fact to find that a joint criminal enterprise, as alleged in the indictment, existed. The question remains, however, whether there is evidence upon which, if accepted, a reasonable trier of fact could be satisfied beyond reasonable doubt that Simatović significantly contributed to this joint criminal enterprise and shared the common purpose. Paragraph 15 of the indictment alleges that Simatović participated in the joint criminal enterprise by directing and organizing the financing, training, logistical support, and other substantial assistance or support to special units of the Serbian State Security Service and other Serb forces that were involved in the commission of crimes. In paragraph 3, the indictment specifically alleges that in or about April 1991, Simatović held the establishment of a training center in Golubic near Knin, which was followed by the establishment of additional training centers financed by the Serbian State Security Service. The trial chamber considers that if the evidence presented by the prosecution in support of Simatovic's individual criminal responsibility is taken at its highest, there is evidence capable of supporting a conviction. With respect to his alleged membership in and contribution to the joint criminal enterprise, Simatović submits that he had limited authority within the Serbian State Security Service. He also contends that there is no reliable evidence that he assisted or took part in any way in the establishment of the training center in Golubic or in the provision of weapons or other material support to the Serb autonomous region of Krajina. He further asserts that the prosecution has not adduced any evidence showing that he shared the intent with the other alleged members of the joint criminal enterprise. The prosecution responds that, to the contrary, there is extensive evidence demonstrating Simatovic's intent and contribution. The trial chamber received evidence of Simatovic's alleged role in the establishment and provision of financial and logistical support to the training centers in Golubic, near Knin, in 1991. According to the evidence of witnesses Milan Babic and RFJ 066, Simatović was in charge of the Golubic training center, and Dragan Vasilikovic, also known as Captain Dragan, was recruited by the Serbian State Security Service to provide training to the units at the Golubic camp. The trial chamber also refers to the evidence of witness RFJ 107 and RFJ 137. The trial chamber further heard evidence that the forces that were trained at the Golubic camp, including members of Matić's police and Serbian state security units, participated in attacks throughout the Serb autonomous region of Krajina. There is also evidence that the attacks on the Glina police station, the village of Lovinac and Plivici were carried out with Simatovic's direct involvement. The trial chamber here refers here to the evidence of witness Babic, RFJ 066 and RFJ 137, as well as exhibits P00256, P01980, and P00048. The prosecution also presented evidence regarding Simatovic's alleged role in the provision of weapons and other material and financial support to Serb forces, including those in the Serb autonomous regions of Krajina. For example, according to witness RFJ 066 and Dejan Anastajević, Simatović provided weapons and financial support to Milan Matić and to the paramilitary group known as the White Eagles, operating in eastern Slavonia. Other evidence indicates that Simatović often had meetings with Arkan, another alleged member of the Joint Criminal Enterprise, and had a commanding role in Operation POC. The trial chamber refers to the evidence of witnesses Dejan Anastajević and RFJ 0111. Simatović further challenges the sufficiency of evidence that he was involved in the establishment of any other training centers in Croatia and Bosnia and Herzegovina. The prosecution responds that there is clear evidence that Simatović continued to build on the training model he established in Golubic by establishing other training centers across or near the borders of Croatia and Bosnia and Herzegovina, including in Lecimir, Korenica, Divic, Doboj, Mount Ozren, and Breko. The trial chamber received evidence that following the creation of the Golubic camp, Simatović visited and materially supported training centers that were established in the same manner and for the same purposes in other areas of the Serb autonomous regions of Krajina, Slavonia, Baranja, and Western Trem, and in certain municipalities in Bosnia and Herzegovina. The trial chamber notes here the evidence indicated that some of the training centers were established by persons who had been either trainers or trainees at Golubic, such as Captain Dragan and Raha Bozovic, who, according to some of the evidence, operated under the overall authority of Simatović. The evidence also indicates that individuals trained in the camps later committed crimes or were involved in attacks across the region. The trial chamber refers to the evidence of witnesses Babic, RFJ 066, RFJ 174, RFJ 004, RFJ 137, as well as exhibits P00059 and P00257. Simatović also challenges the sufficiency of the evidence that the Serbian State Security Service was involved in the establishment of and had control over the Scorpions or the Serbian Volunteer Guard, which was also known as Arkan's Men. The prosecution responds that this submission ignores the totality of the evidence presented in the case. The trial chamber has already mentioned evidence regarding Simatovic's connection to Arkan's Men, including in relation to Operation PAUK. In addition, witness RFJ 088 discussed the various meetings between Arkan and Simatović and how Arkan took orders from the Serbian DB. A crime report admitted into evidence and commented on by witness RFJ 037 also details the activities of Serb forces in various municipalities in Bosnia and Herzegovina, and the link between some of them and Simatović. Finally, witness Goran Stoparić stated that he was a member of the Scorpions, that he reported to Major Botka, who reported to Simatović. In the trial chamber's view, if this evidence is accepted and taken at its highest, a reasonable trier of fact could be satisfied beyond reasonable doubt that Simatović shared the intent and made a significant contribution to the common criminal purpose to forcibly and permanently remove, through the commission of crimes, the majority of non-Serbs from large areas of Croatia and Bosnia and Herzegovina. Accordingly, there is evidence capable of supporting a conviction under each count of the indictment against Simatović. Therefore, the trial chamber dismisses Simatović's motion for a judgment of acquittal. The trial chamber reminds the parties that, in accordance with the order on Rule 121 proceedings in preparation and commencement of the defense case issued on the 19th of February, the pre-defense conference will be held on the 30th of May, 2019. Also, as discussed informally with the parties, the trial chamber anticipates commencing the presentation of the defense case on Tuesday, the 18th of June, 2019. Are there any housekeeping matters which the trial chamber need address before we take the adjournment?
No, thank you, Your Honor.
For the prosecution, Your Honors.
Ne, hvala, časni sude.
Nothing, thank you.
Close today's proceedings.
All rise. Way, Boulevard.